A very warm greeting. This is Shashank Mishra, represent as the host of Law and Life with the renowned senior advocate of Supreme Court of India, Subodh Markandeji. This channel is an step by senior counsel to share the year of experience with recent legal issues, informing political history of India and other similar topics. Topic of this session is the first anti-love jihad conviction and sentence in UP. The first ever judgment in convicting and sentencing an accused under the Uttar Pradesh Prohibition of Unlawful Conversion of Religious Act 2021, popularly called Anti-Love Jihad Law, has been delivered by Dr. Kapil Raghav, Additional Special Judge, POSCO Act 1, Amroha on 16 September 2022, in Special Criminal Case number 237 of 2021. How do you react on that, sir?
The order of conviction and sentence passed by the learned additional session judge, that is special judge, POSCO cases Amroha, has proved the love jihad to be a stark reality. What was so far a matter of speculation, I think a separate episode debating the constitutional validity of this Uttar Pradesh law is imperative.
So, what are the facts of the case? Can you please tell?
Prosecution case is that the victim, you see, her name is not disclosed as per Section 33(7) of the Protection of Children from Sexual Offences Act 2012, that is called shortly POSCO Act. She is the minor daughter of the complainant Sharad Kumar Agarwal, resident of Singhali Jagir, police station Hasanpur, uh, in district of Amroha. He runs a nursery called Gaurav Nursery. About a month prior to the date of incident, that is 2nd of April 2021, the accused Afzal came to the said nursery in a hired vehicle to transport some plants from the nursery. There, the victim, her mother, and her siblings had also come. The accused, concealing his religious identity, introduced himself as Arman Kohli, a devotee of Lord Shiva, and he befriended the victim and obtained her mobile number. He was chatting with her for those 2 months, constantly with her. On 2nd of April 2021, when the victim's mother, Parul, woke up at 5 o'clock, she found the victim missing. So she woke up her husband and his brother and his nephew, and all of them searched all around the neighborhood. They met Faisal, Shabbu, and Subhash, who informed them that they had seen the victim with 4 other persons, out of whom 2 were women. So, after day-long search with the relatives and friends, they could not find the victim. So, uh, at 7 p.m., around 7 p.m., the victim's father gave a complaint in writing in the police station, which was acted upon, and crime number 139 was registered under section 363 and 366 of the Indian Penal Code and sections 3 and 5(1) of the Uttar Pradesh Prohibition of Unlawful Conversion of Religion Act 2021. The investigation was immediately commenced, and after 2 days, the minor was recovered from Silampur police station, Usmanpuri, Delhi, in the company of the accused.
So, what charges were framed against the accused?
So, after investigation, charge sheet alleging commission of offences under section 363, 366, 351, and 506 of the Indian Penal Code, sections 7 and 8 of the POSCO Act 2012, and sections 3 and 5(1) of the Uttar Pradesh Act was filed against the accused.
Sir, is there any evidence was led by the prosecution and defense?
Prosecution produced PW1, that is father of the victim, PW2, Sonam Rathi, who was the scribe of the FIR uh, and who copied the FIR, PW3, Parvendra Singh, headmaster of Vishwabandhu Academy, Amroha, where the victim was studying for her 12th class. PW4, Pallavi Gangwar, who performed medical examination of the victim. PW5, Gajendra Pal Singh, the investigating officer of the case. And PW6, the most important witness, the victim herself. The documentary evidence consisted of complaint dated 2/4/2021, Exhibit K1, FIR of that date, Exhibit K2, entry in the general diary, Exhibit K3, Exhibit K4, victim's registration form for class 4, showing the date of birth, Exhibit K5, SR register, Exhibit K6, high school mark sheet, which also showed her date of birth, certified copy of that, and Exhibit K7, photocopy of the same high school mark sheet, uh, Exhibit K8, medical report of injuries on the victim, Exhibit 9, P9, site plan, uh, Exhibit K9, the medical report showing the injuries on the victim, Exhibit P9, site plan from where the victim was abducted, Exhibit K10, the FARD, and Exhibit K11, charge sheet. Now, the defense, that is accused, examined himself under Section 313 of the Code of Criminal Procedure and examined D1, Muhammad Faizan, and D2, Mahmood Hassan, in support of his plea for alibi.
How long did the trial last, sir?
The trial lasted for 1 year, 3 months, and 15 days.
So what were the findings recorded by the learned judge?
So these are the findings. After perusing the entire evidence on record, reading the provisions of the 3 laws involved, and the judicial precedents, the learned additional uh, special judge POSCO cases held as follows. 13 hours delay in lodging the complaint in writing in the police station is bona fide, well explained, and does not affect the prosecution case adversely. Second, the burden of proof of date of birth of the victim and her age, that is 16 years, has been discharged satisfactorily by the prosecution by cogent evidence as per Section 94 of the POSCO Act and the decision of the Honorable Supreme Court on the interpretation of that act in Jarnail Singh versus State of Haryana, 2013, 7 SCC 263. The burden of proof regarding plea of alibi lay on the accused, which the uh, statements of witnesses DW1 and DW2 failed to discharge, and therefore the plea of alibi must fail. Now, on merits, the trial judge gave the following findings. The prosecution has proved that accused was kidnapped. The accused kidnapped the minor victim from the lawful custody of her father. Such kidnapping of the victim was with the intent to marry her against her will, and seduction was for the purpose of having illicit sexual intercourse with her. Third, the medical report also established that accused also assaulted the victim. Fourth, he also criminally intimidated the victim. Fifth, the accused also committed the offense of sexual assault on the child victim within the meaning of Section 8 of the POSCO Act, and he is liable to be punished under Section 8 of the POSCO Act. And lastly, the accused also attempted to convert the victim from her religion, that is Hinduism, to Islam by practice of misrepresentation, that is giving his name as Arman Kohli and claiming to be a devotee of Lord Shiva, and by fraudulent means, which is punishable under Section 5(1) of the UP Prohibition of Unlawful Conversion of Religion Act 2021.
So, what sentences were imposed by the learned judge on various counts and whether they will run concurrently on consecutively and the fines, if any?
The judgment was rendered on 16th September 2022. The next day, the learned judge took up the question of sentence. So, uh, uh, on various counts, and whether they will run concurrently or consecutively, and the fines, if any. So, on 17th 9 2022, the Learned Trial Court imposed the following sentences. For the offences under Section 363 Indian Penal Code, 3 years rigorous imprisonment plus fine of rupees 3,000, in default of which 1 month's ordinary imprisonment. For offence under Section 366 of the Indian Penal Code, 5 years rigorous imprisonment plus fine of rupees 7,000, in default of which 2 months ordinary imprisonment. For offences under Sections 7 and 8 of the POSCO Act, 3 years rigorous imprisonment and fine of rupees 5,000, in default of which 2 months ordinary imprisonment. For offences under sections uh, 3 and 5 of the Uttar Pradesh Act, 3 years rigorous imprisonment and fine of 25,000 rupees, in default of which ordinary imprisonment for 6 months. She further directed that all the sentences will run concurrently. And lastly, half of the fine, when recovered, will be paid to victim as compensation.
So are the sentences too harsh so as to make vulnerable to be set aside?
No, considering that all the sentences will run concurrently, uh, so effectively the accused will remain in jail only for 5 years. Total fine of uh, rupees 40,000 does not appear to be excessive, considering the seriousness of the offences and also the need for deterrence. But since we are all used to very low fines, some arguments would naturally be advanced in appeal that punishment is excessive.
Thank you, sir. With that, we will be winding up for the day. And that's all for the day, sir.
Thank you, Shashank.